Hello everyone, welcome to the third session of Legal Update Special Edition for your CLAT examination. Uh, I hope all of you are going ahead very strongly with your preparation. We don't even have 1 month left for the exam, so I hope uh, things are going well. Legal Updates is one of the efforts that we are putting for uplifting, for expediting your preparation. We have other series as well. Please check them out. Now, we already have had two special edition sessions before. I hope you have watched them. This is going to be the third edition. Uh, I've got some very interesting updates, very important ones that were quite consistently seen in the newspaper, both Hindu and Indian Express. So becomes important from exams perspective. First one is with regard to disqualification of MP and MLA. I'm sure you would have heard about Lily Thomas case somewhere, maybe in the news or some articles, some journal, yes, or maybe in your mock tests as well. So let's see what it was actually about. So uh, Lily Thomas case, in this case, Supreme Court held a particular provision with respect to disqualification of MLA and MPs unconstitutional, right? So we will basically talk about that and why was it held unconstitutional. Uh, it was about Article 101, Clause 3 and Article 190, Clause 3, which basically says, in Constitution, it says, it stops the Parliament, right? It says that Parliament should not defer the date from which the disqualification should come, correct? So this is what the provision of the Constitution is saying, right? And there were certain provisions which went against this. And those provision, what was that provision? It was Section 8 of Representation of People Act. So basically, these two, or say two provisions on one side and one provision on the other side, they came uh, contradictory to each other. There was constitution on one side and there was representative of people act on one side, and hence the court basically said that the act, the statute, there cannot be any provision which can exceed the power which has been given in the constitution. And the moment you give any such power which has been prohibited in the constitution to any body, here in this case it's the parliament, it amounts to ultra vires. Please let me know what ultra vires mean in the comments box below. Now, uh, as I told you, Section 8 was something which was under conflict, right? So it basically says that disqualification should take place only after the 3 months uh, are over, right? From the date of the conviction. So those MPs and MLAs who have been convicted of very serious offenses, they are mostly disqualified from the election, right? From that's where we talk about the disqualification of MP and MLA. So in that case, Section 8, Clause 3 says that it should take place after 3 months, right? And Section 8, Clause 4 prohibited them till 3 months, right? Before appealing also. So even before, I mean, even if those MPs or MLAs, they want to appeal, they'll have to wait for three months. That's what was made unconstitutional under Lily Thomas case. Now, very important, this was just a story, right? Just to connect this Lily Thomas case is a judgment just for you to connect uh, some kind of fact to a very important concept, and that concept is disqualification, right? So Article 102, Article 191, they provide us with certain grounds on the basis of which MPs and MLAs can be disqualified from election. What kind of grounds am I talking about? They are holding an office of profit. So if there's an MP or MLA, if they're holding any office of profit, right, outside the elected office where they are in that case, they shall be disqualified. I hope you know that one MP cannot hold two government offices, right? If in case the person is interested in some other position, he or she will have to resign or will have to step down from the previous office, then only they can join the another office of profit. Other than that, if a person uh, turns unsound, right? So that is also one of the grounds on the basis of which disqualification can happen. Other ground is insolvency. And the next one is about the validity of the citizenship. So if there's a person who is not a valid citizen of India, such person cannot be a part of election, right? So they can be disqualified from the election. Now, this was just one area from where we get some grounds of disqualification. There are two other areas as well. One is 10th schedule. I hope you are clear with all the 10 uh, schedules, right? Are very important. All the 12 schedules actually, 11 to not very important, but yeah, please go through them. Just try to relate some stories to each schedule, and I'm sure you'll be able to memorize it. So 10th schedule talks about anti-defection laws. So from there also we imply some kind of disqualification grounds. Next one is Representation of People Act 1951, of which the section 8 was being talked about. You know, we were talking about section 8, which was under conflict and in this case. So that comes from RPA 1951, which says that if a person is convicted in a criminal case, convicted, okay, please mark my words, it's conviction. We are not talking about an accused person, right? So if there's a person on whom there is a trial that is still running or it's still pending, or the person has not been convicted or just been, it's just at that stage, in that case, we cannot disqualify that person. Mark this word, it's about conviction. If you get a passage in this regard, this can be something, where you can get confused, right? So please mark this word very consciously. Next one is about rights of unborn child. We have been hearing about this case since last 2 to 3 years quite consistently, right? After every few months, Supreme Court uh, comes up with some kind of statement or some kind of judgment or some kind of interpretation, new interpretation. So this year as well, we got some interpretation with respect to the MTP Act. So let's see what was it about. Uh, Context: there was a woman. She was married, already a mother of two. She was 26 week pregnant, and she did not want to bear that. Right? She did not want the third child, and that's why she wanted to terminate her pregnancy due to certain, mental depression case and financial constraints and all of those grounds. Now, uh, for that, she approached the court for abortion and for the legal abortion. And then, while going through this case, there were two new concepts that arose. One was fetal viability, and second one was about the rights of an unborn child. Now, initially, there was a bench of two judges who allowed it, right? They allowed the abortion of unwanted pregnancy up to 24 weeks. But again, there was a concern with respect to fetal viability, right? This was because of certain doctors from AIMS, Delhi, who came up with this concept and who actually brought this uh, to the notice of the court. And on the basis of the opinion of the doctors, there was a split decision which was given by the same bench, right? Later on, again, a three-judge bench with our CJI as well, that is Justice D.Y. Chandrachud, it came to his bench along with two other judges, and uh, the case actually started afresh, and they started talking about the fetal health and women's medical condition as well, right? So that's why this entire debate started going on with respect to the fetal's fetus right, and on the other hand, the mother's right. So entire debate, entire discussion on that. However, talking about the abortion laws in our country, it simply says that it can be, we have one law, right? Medical Termination of Pregnancy Act. I'm sure, again, you would have come across this term in newspaper multiple times, because if you're consistent with the newspaper, you would see this, right? It is something which keeps coming in newspaper after every few months. Now, in this act, there are certain regulations. Basically, there are certain conditions which have been given for every stage of pregnancy, right? So, termination up to 20 weeks. For that, you need the woman would need one doctor's advice, just one doctor advice, and it's good to go. But when the termination has to be done for 20 to 24 weeks, in that case certain specific uh, requirements are there, wherein two registered medical practitioner needs to give consent, right? And if it is beyond 24 weeks, in that case medical board's approval is required, and only in case of very substantial fetal abnormality such abortions are allowed. Now, what does this fetal abnormality mean? Suppose it is a fetus. If the doctor says that this child cannot survive a healthy life, or will have some long life kind of disease, or will be anything of that sort, in that case termination can be allowed medically, but only after medical board's approval, right? Next one is about the parliamentary privileges. PV Narasimha Rao case have been quite famous since a while now. So there was a time in 1980s when there was a leader who was caught for bribery, right? And that leader, that politician, used Article 105 and 194, right? Wherein privilege has been given to the parliamentarians and the state legislatures against such arrest, right? So that happened then. And recently also, something happened similar to that, but Supreme Court allowed the parliamentary privilege in that era, but now uh, it's sort of reviewing the correctness of that verdict which was given, right? So that was the old PV Narasimha Rao case, wherein section 105 was used, and again this time MLA Sita Soren has been caught for bribery. She was not caught, but accused for bribery. And she again has invoked Article 194 for the immunity. But her request has been declined, and it is still under investigation by the court, with respect to the correctness of the last judgment which was given in 1998. Now, what about the privileges and immunities that MPs and MLAs enjoy? First one is their freedom of speech, right? They have freedom of speech and nobody can stop them from speaking anything, correct? That is one. Second is that an MP cannot be held liable for any kind of proceeding before the court for anything that is said inside the parliament or any committee, right? So you can nobody can file a case against that MP for something which has been said inside the parliament or in a committee meeting. Similarly, if there's any publication with respect to reports or papers, publications, or anything of that, or proceeding, right? If it is happening by the parliament, right? Parliament means on behalf of parliament by the MPs, in that case, such person shall not be held liable for such publication as well. Means liable, right? Next is that see why these kind of protections, these kind of privileges are given only to ensure that there should not be any hindrances in the democratic setup, democratic functioning of the country. And that is the reason such parliamentary privileges are provided to MPs, and the similar kind of provisions are given for MLAs as well, along with the MPs. Next one is about the Forest Conservation Amendment Bill in 2023. Environment law is something which is actually catching the heat since last few years. Even CLAT is asking questions around such topics, so becomes important from our exams perspective. Now, this is the amendment bill which has been proposed this year. by our Ministry of Environment, Forest and Climate Change. And it basically seeks for certain amendments in our uh, uh, existing Conservation Act, right? So what kind of amendments are being sought? First one is with respect to Forest Conservation Act 1980, wherein uh, they seek to conserve the forest by the way of restricting any kind of dereservation of forest and forest land for non-forest purposes. That is one. And second is with respect to the prior approval of the central government officials. If there's anyone who wants to get into a dereservation, prior approval of the central government shall be required. Next one is with respect to forest dwelling communities, STs and other traditional forest dwellers. They are given such rights. They are exempted from forest clearance rules, right? Because they are considered to be locals. They are considered to, because they are so much dependent on the forest and the forest products. So they are involved under this, and hence they are exempted from any such clearances. Second one is with respect to the recognized and the vested forest rights that ST and forest dwelling communities get, right? So that separation, that kind of definition, specification is also required. So Bill is talking about that as well. Third one is with respect to involvement of the Gram Sabha for monitoring the community at different levels, right? Uh, Next one is about other uh, proposed changes which are sought under Forest Conservation Act. Very important. They, apart from uh, forest land nearby railway and public roads and national highways, yes, national security areas and defense areas and public utility projects, all of these are the areas which have been given exemption from the Forest Conservation Amendment Bill, right? So which is actually very important, because there has been certain controversy which was going on around this, right? Because government was facing certain issues and there were environmentalists who had issues with this. So that development and sustainable development had a tough competition here, a tough time here. So important from that perspective. Next, about the implication and the concerns, uh, there are certain concerns was which actually experts have been talking about. First one is about the exemption of forest dwelling communities. So there are certain concerns with respect to that, because so far STs have been given quite a lot of exemptions, but now the act is given a lot of importance to forest dwelling communities as well. So that is attracting some kind of concerns. That is one. Second is with respect to the consent and the clearance of the authority, the kind of process it has to go through for the resolution. Yeah, so that is something which is a matter of concern. Other than that, there was a wide definition or wide extent of forest land definition which we had in the law before, and now it is this bill is trying to narrow it down, narrow down the definition of the forest land. So that is also something which is going to give a good amount of clarity to us, right? Other than that, on one side it gives clarity with respect to few things, but there are certain things wherein we do not get clarity as such, right? Like, for example, the objective of the bill, right? Every bill, every act should have some objective. So this bill is going haywire. There's no such objective which can be streamlined from this. That is one. Second is about the compensatory afforestation, right? So if there's a person or if there's a community or the company who is going for large scale afforestation, there's no such compensation kind of provision which has been mentioned. So that is something which is lacking. And with respect to creation of new forest and tree cover also, compensation and procedure and all of those stuffs are missing. So that is a drawback of this bill. Next is Bharatiya Nyaya Samhita. Though after hearing this, initially when this was introduced by the government, everyone was very perplexed as to what is this, right? But it is simple, our simple IPC, right? Our favorite IPC. So this is what it is. So, as you know, IPC was brought in during British eras by Lord Macaulay. And now, since then, we have been following IPC. It is quite regressive. I mean, some provisions are quite regressive. Of course, most of the provisions are still relevant, but some provisions are still regressive. And hence, there's a requirement of vast amendments in our criminal justice system through IPC. And that is what Bharatiya Nyaya Samhita is doing, right? So it is about the amendments. Now, what kind of amendment are we doing? First is with respect to the he and she thing, right? So it is so now it is going to be gender neutral provision. No he, no she, nothing like that. It is going to be simple gender neutral provision, right? That is one. Second is with respect to unnatural sexual offenses against men, which was, punishable before. Now it is not punishable as per IPC, right? Second is with respect to the definition of community services and life imprisonment. These are very vague terms, right? Different courts, different judges used it differently, different experts used it in a different way. Now the law, through amendment, we are going to get some definition here, right? Some kind of specification with respect to these terms. So that is going to give some great amount of clarity. Next is with respect to sedition. I'm very sure you would have heard about sedition a lot by now. And as you know, Supreme Court has sort of put a stay on sedition, right? It's almost a year, I guess now, almost a year since when sedition has been stayed, and the Supreme Court asked the government to review the provisions of sedition, right? So these sedition related provisions are also something which is undergoing amendment, through which sedition is basically an offense. It is covered under the offense against the state, right? Wherein uh, any person's act, right? It endangers the sovereignty, unity, or integrity of the country, not the government. Okay, it's about the country. It's about, or say, it's actually about the government, but it's not about a particular person. So, if a person says something about a particular leader who is known for uh, who's the face of the government, or maybe who's the face of the country, it won't amount to sedition. Why? Because it is against a person. But the moment the statement or the act goes against the sovereignty, unity, and integrity of the country, in that case it will amount to sedition. Yeah, so it is actually a very, very important concept from your exams perspective. Also, there has been a lot of debate, lot of discussions with respect to sedition. I'm sure you would understand that the Supreme Court has put a stay on a government's favorite uh, so-called favorite provision, so it has to be the topic of the town. Next is with respect to mob lynching, something which was not very expected, but yeah, it's like tightening this law by putting capital punishment for mob lynching, right? It's because since last few years we have been reading about a lot of cases regarding mob lynching, and hence there was a need of stricter punishment with respect to this, and hence the capital punishment. Next is terrorism being defined. Previously, it was not, there was no definition of terrorism under IPC or under any such law for us. Yes, everybody had their own interpretation. Now we are going to get a strict legal definition for this. And the provision with respect to adultery is going to be omitted. Uh, there are also provisions respect to speedy legal procedure. Charge sheet should be filed within 90 days. After that, suppose police wants even more time, or investigation authority needs more time, in that case court can extend it for further 90 days only, not more than that. And after that, the entire trial should be over in 180 days, and judgment should be given in 30 days. So this is the timeline which is going to be there in our new IPC, in the amended form of IPC. So something which is very interesting, and I'm sure once you will go to your top NLU, you will get to learn about this more, because by then we will maybe get the new version of IPC. And yes, that would be it from my side, guys. Thank you so much. All the very best. And if you have any question, please feel free to ask. Thank you, everyone.